The High Court has today ruled that Prince Harry's case against Associated Newspapers Limited can go forward. However, there is a huge blow to the case, which I'm going to explain in short in this video. I'll try to keep it short anyway. But if you are confused as to which case this is all about, this was about the alleged interception of voicemail messages, listening into live phone calls, and obtaining information by deception, and the use of private investigators, collectively known as the unlawful information gathering, all of which, of course, has been denied. So let's move first of all to, this is the press summary by the courts and tribunals judiciary. This is available online. It's a publicly available document, and I'm going to add some sort of flesh to the bones to help you understand it here. So the claim is summarized here that the claimants, which includes Prince Harry, allege that Associate Newspapers has in the past obtained their private and or confidential information using techniques such as interception of voicemail messages, listening to live phone calls, and so on. Accordingly, they seek remedies for the misuse of private information, including damages and an injunction that will prevent them from doing it in the future, if indeed they are found to have done that. Because, of course, Associated has denied the allegations, and it's important to be absolutely clear that at this early stage, the court is not adjudicating on the truth of any of the allegations that have been made by Prince Harry and others. So just in case anybody was misled to believe or misunderstood that there's any truth to this adjudicated so far, that is not yet the case. Now, there's been a number of challenges. If you remember, just to recap those, there's no defense filed so far by Associated because they, at the very early stage, tried to have the claim thrown out on two separate grounds. You'll remember, first of all, there was the argument of limitation, which meant that this claim was brought too late, because for claims of this nature, if they are brought after 6 years, then usually they are statute barred and they cannot be brought. However, there is one possible argument against that, which is under Section 32 of the Limitation Act 1980, which does provide that where there's been any argument of fraud, concealment, or mistake, that there might be an argument that this time limit doesn't begin to run until any prospective claimant has discovered any such concealment. And that stands to reason, because if somebody has concealed information and 6 years go by, then you find out about it, it wouldn't be fair that you're not allowed to bring a claim after 6 years just because you hadn't found out about the information. So that was one of the arguments raised here. And just while I have your attention, please do be very careful at the moment if you receive any messages purporting to be from your bank, whether they're asking for money, asking you to transfer money, or anything like that. There are a lot of scams going around at the moment, and there's a lot of reports of increased activity, so please do be careful. But also a huge thank you to all of you that have used my Octopus Energy referral link, which I'll put in the description below. All of those that have switched to Octopus will receive £50 credit on their account, and of course I get a kickback as well because it's an affiliate link for full disclosure, and so that helps support me on this channel. Back to the video. The second part warrants a bit more explanation, which I have read in the comments some people have struggled with. Let me zoom in just a little bit and move it across just a little bit. Some people have struggled with this second part. The second part of this challenge by Associated against this claim to have it thrown out was that parts of the particulars of claim, that is the document which provides the statement of facts, the facts upon which a claimant relies to bring their case, that parts of that particulars of claim relied upon certain documents from the Leveson Inquiry. Now, this I'll go into in another video, which was in short a public judicial inquiry into the culture, practices and ethics of the British press following News International's phone hacking from years ago. We've talked about that in other videos. So the second ground of challenge here was that these particulars of claim relied upon certain documents from that inquiry. Now, these documents are referred to as the ledgers. Now, Associated's argument was that these ledgers were subject to a continuing restriction on the use as a result of a final restriction order. And that was made during the Leveson Inquiry, pursuant to Section 19 of the Inquiries Act 2005. In other words, the argument was that the claimants, which included Prince Harry, were prohibited from using these ledgers to fill out part of their claim. So, in other words, their particulars of claim stating out the facts upon which they rely to bring their claim relied on the whole or parts of these documents to plead those particulars within the claim. And the argument by Associated was that they did so without taking any steps to modify or discharge, remove those restrictions. So just to recap, those Leveson Inquiry documents, the ledgers, formed part of the claimants, including Prince Harry's particulars of claim, but they were subject to a restriction order under Section 19 of the Inquiries Act, and without having that order modified or discharged so that it no longer applied. Of course, the claimants accepted that they'd received copies of these ledgers. They argued that on proper interpretation, they were not subject to these restrictions. And so that was the second ground that the court had to decide on in this case so far. Of course, to the contrary, Associated argued that the use of these ledgers was prohibited as a result of undertakings provided by the core participants to that inquiry, and thus should not have been used in the particulars of claim. Now, on the one hand, you might read from headlines about this that Harry's case goes forward, that it's a big win for Harry today. That is because on the first argument, the court dismissed the limitation application by Associated to have the claim thrown out on the grounds of Section 32 of the Limitation Act, i.e. concealment. The judge found that a large amount of evidence was filed by the parties and considered by the court, but the judge held that the appropriate stage for the court to determine the facts necessary to resolve any limitation defense, including the issues that are arising under Section 32, would be at trial. So the court has essentially decided this must go to a trial to really decide on this issue. And at this stage, the court, coining a phrase here, the court said Associated has failed to deliver a knockout blow to any of the claims brought by the claimants. So their argument on the limitation aspect, which would have killed the claim entirely, was unsuccessful. So their application on limitation grounds to knock out the claim entirely was unsuccessful. So those issues on limitation are still to be decided. They haven't been decided yet, which you might be led to believe from some headlines. They have not been decided yet, so the limitation argument might still succeed, but that will need to be decided at trial. So this is why sometimes you read a headline, you might make an assumption about it, but when you read into it, this is still only the press summary, not even looking at the judgment yet. I'll probably do that in the second video, but even just looking at the press summary, the court has still yet to decide these limitation issues. The court said here that the appropriate stage for the court to determine the fact necessary to resolve any limitation defense, include the issues arising under Section 32, i.e. concealment, need to be decided at trial. So it is not, just to repeat, the case that the court has decided that Associated has concealed anything at this stage. The court has said that needs to be decided at trial with full evidence. So you could see this first issue as a win to Harry, although it's not completely won yet, it's just deferred, if you like, to the trial. So it needs to be decided at trial. As to the second, this is where I say that there's a significant blow, because as to the restriction order application, the court upheld Associated's objections to the reliance on these ledgers. So the court has said that these particulars of claim should not have relied on these ledgers without a modification or discharging of that restriction order. And so in the conclusion, moving down here, the court has said that following the dismissal of the limitation application, the claimant's claim will continue. However, the upholding of the restriction order presents several options. They can seek a variation or revocation, have it revoked entirely, of the final restriction order. Now, in my view, it's unlikely that there's going to be a revocation of that final restriction order because it was in place for a reason, it was an important order, and in my view, it's going to remain. It's possible that there would be a variation to that order to use certain parts of the ledgers within the claim, but that is very much more nuanced and would require a lot more analysis and very much more time than I have on this video. Alternatively, the obvious alternative here is that the claimants, including Prince Harry, of course, could remove those parts of the particulars of claim that have relied on information drawn from the ledgers. So that is the blow, potential blow to this claim. They would have to carve out chunks of the claim that relied on information from these ledgers, because, of course, they were subject to this restriction order. The final option, which I don't think would happen, is that Associated could give voluntary disclosure and inspection of the ledgers to the claimants, but that's not something the court can order because, of course, with the restriction order in place, it is for Associated to decide really whether or not they provide those documents. Now, this really warrants another bit of explanation on the disclosure process. Disclosure, which is called discovery in the United States, or very broadly the same thing in the United States, is where parties tell the other side what documents they have that support or hinder their own case. And it's provided in the form of a list of documents and the steps that have been taken to discover what those documents are. Probably why the US call it discovery. But it's a list of documents, i.e. we have an email dated this which says something along the lines of, but also categories of disclosure, such as we have this document and you are allowed to see it if you want it, which is called inspection, or for certain documents which might be legally privileged or restricted in another way, such as these that are restricted documents, which might say we have this document, which is this kind of document, but it is subject to certain restrictions and therefore you can't see it. There are also other documents that you may know that exist, but which you do not control, but that must still come within your disclosure process. So, for example, you might say, we know this document exists, but it's in the custody of whoever, and we don't control it. And even then, it might be subject to privilege, for example. So this disclosure process will set out all of these different documents and whether or not the other parties are entitled to look at them. And then that stage will become the inspection stage. And then, of course, there could potentially be applications for specific disclosure, which is where a party believes a certain document to exist but has not been disclosed. There might then be an application to require by order that that party disclose that document, i.e. say what it is, where it is, and broadly what it says, and whether or not there's an entitlement to inspect that document. And so that is broadly how this works. And so for any parties that think that they can just keep documents back and hide them and not show their cards, as it were, that is not how it works. But in a case like this, where there is a document which is subject to a restriction order, they should not be relying on it generally, although the argument here by the claimants was that it should not be interpreted to restrict reliance on it in this way. But the court didn't agree. So the court here at paragraph 14 of the press summary, the judge has concluded on the evidence that copies of the ledgers provided to the claimants by the online publisher had come originally from a person or persons who had received or had access to them during the course of the inquiry. In other words, they'll be subject to those restrictions. The provision of the ledgers to the online publisher was contrary to the final restriction order because it amounted to disclosure or publication within the terms of that order, and by the same reasoning, the provision of the ledgers by the online publisher to the claimant's solicitors was contrary to the final restriction order. And in consequence, the judge found by analogy with restrictions that are placed on further use of documents that have been disclosed in litigation that the court could not permit the claimants to use information derived from the ledgers in their claim for as long as the ledgers remain subject to the final restriction order, which is why one of the steps is to seek for a variation or revocation of that final restriction order. But as I say, I can't see that this is going to be revoked, and even a variation might be a difficult task, but doubtless that is an application that they will consider to make. So I hope you found that an interesting overview of just the press summary. If you want more discussion on the judgment itself, I will dive into that. It's literally been released this morning, so I haven't had time to go through that yet. But this is an overview of what that press summary says and why the claim will go ahead, but why there's a huge blow to it. Let me know any thoughts, comments, questions in the comments box below. Please do hit the subscribe button. That really helps. And in the meantime, check out one of these videos here if you want to read a bit more about the background to this case. And as always, thank you for watching.